instruction on tape, I might agree, but they specifically state they've listened to it repeatedly, and their question seems to imply that they have divided the standard of proof into two segments, moral certitude versus beyond a reasonable doubt. And I think that perhaps what that's indicating is that there is a confusion on their part that there are two separate standards, one a moral standard and secondly a legal standard. And I think we have to somehow disabuse them of that notion, because it's not what their morals think and what their minds think. It is a reasonable and moral certitude. It is all part of one instruction which satisfies them both to a moral certainty and to a reasonable doubt. So I think that they are looking for clarification on that, and I sincerely doubt that just repeating what they have on tape will do anything but frustrate them further. So I think perhaps putting a little bit of time into this response would be well worth it. They're clearly indicating a desire to work through what they previously reported as a deadlock. I don't know if perhaps letting them take their lunch break at this point while the attorneys in the court make an effort to respond to this in a meaningful fashion would be worth it. I think with how far we've come, a little bit of extra time here and care in responding to this in a manner that may help them would be well worth it.
Good.
I'm not going to rewrite the Webster instruction.
Well,
and again, as I read that question, the specific language they're honing in on is moral certitude, which appears in only one place in the instructions, and that is in the context of the Webster charge.
It appears, at least with what I'm holding here, it's repeated twice in the modern syntax.
Well, as I said, I didn't use the moral certainty language twice, and I often don't even use that language, moral certainty, but I noted that the defendant requested it, so I use that generally. I've used just reasonable certainty rather than moral certainty, but the defendant specifically requested it, so I did use it in this particular case. I know that the courts have been for over a decade struggling a little bit with this moral certainty language, both on the federal level and state level, but seemed to have been satisfied based on what we're being directed to give as the modern syntax version of the Webster charge, that in context, that language moral certainty does not suggest that type of almost religious, moral decision making.
What I would propose then, Your Honor, is without changing the language that the court has used or what's laid out in Webster, is that we clarify for the jury that when we're using terms like moral certainty to a reasonable certainty or a near certitude, that these are synonymous terms. These are different ways of describing the same level of certainty that they must have in order to convict. And I think that is a fair reading of Webster. It's not, moral isn't higher than reasonable, nor is it less than. Near certitude is not less or more than a moral certainty. It's all the same, different ways of expressing one standard here. To a reasonable certainty, of near certitude, to a moral certainty. These are synonymous terms, different ways of expressing the same standard of proof. And I think that's what their question's calling out for here. They've drawn a distinction between moral certainty and reasonable doubt, as if it's two different prompts, and it's not. So without changing the language one bit, I'm asking the court to clarify that these are synonymous terms, different ways of expressing the same standard. There's one standard here, just one. And they don't seem to understand that at this point.
No, I object to that, Your Honor. Look, jurors ask questions all the time that can't be answered. We oftentimes tell jurors, I'm sorry, I cannot answer that question. I cannot give you any definition beyond what has already been given you. And I think this is one of them. I think that if you reread the instruction, maybe coming from you as opposed to listening in on the tape, it will have the desired effect. But I really object to adding any language or detracting any language or changing any language from the reasonable doubt instruction that's already been given. You got it right the first time. They've heard it. If they're struggling with it, many juries struggle with it. I don't think you can attempt to tinker with that instruction, and I think it would be a mistake to do so.
Well, I'm going to do this. As I said, I generally don't even use that moral language in my instructions. What I will do is, but the defendant requested it here initially. I will follow the modern syntax that's recommended by the Superior Court Criminal Jury Instructions, the most recent, and expand on my original instruction only to this extent. Must convince you of the defendant's guilt to a reasonable and moral certainty. And I'm not going to try to explain what is and is not similar, because I'm afraid we'd be treading on very thin ice by me trying to go any further with the meaning of reasonable doubt. It's been set out for many years. This is the instruction we're told to give, and I have to say, many times when judges go a little off the track, that's exactly when the problems arise that the courts need to deal with on appeal. So that's the way I will respond, by rereading my original instruction, but using that language in the next to the last sentence as reasonable and moral certainty in accordance with the Superior Court Webster Charge Modern Syntax instruction. And your objections are noted on both sides. But otherwise, it will be identical to the instruction we gave originally. I will, however, to the extent, Mr. Hoos, that you're concerned, I will just simply say to the jurors that they're to follow this instruction that I'm about to give them on reasonable doubt, but they're to consider all of the other, apart from this, all of the other instructions I've given them up till this point on other matters. Okay?
Judge, I just want to make sure, that my objection to any change in what you've already given is preserved. I don't
Absolutely.
have to come up and object again.
No, you don't need to do so, Mr. Miller.
And, Your Honor, if I could just also request that in prefacing your instruction to the jury, you clarify for them that you're answering their question in one
Yes.
part with one answer.
Yes.
To imply that it's not two separate questions here, but it's one question. Because again, I'm really concerned that they're getting hung up on moral certainty as if it's something separate.
I could simply say to them that the response to their question is contained in the definition of reasonable doubt, and then just go from there.
Thank you.
Okay.
Before I'm sorry to, at the last moment, I'd just like some crystal clarity on whether or not Your Honor is going to give the modern syntax as it was just handed to me, or whether it's going to be a blend of that with your prior instruction.
I'm going to give my prior instruction, but just adding that reasonable moral certainty to it. But my prior instruction is not exactly the almost exactly what is set forth in that instruction.
Because I know that the near certitude language, although there's precedent for that, I don't know whether that's necessarily part of the standard Webster charge, or whether that's something the court
I'm going to use that language.
entering. Court is back in session. Please be seated.
Members of the jury, we did receive your question. I'm sorry that there was a bit of a delay, but I'm actually impaneling a jury on another trial, so we needed to get to a point where it was a good point to break on that matter, and also I needed to discuss the question that you sent out with the attorney. So thank you for your patience. Let me just read the question that you sent out first, and then I will respond to it. Your Honor, despite having listened to your instructions several times, the jury would like further instruction, clarification on the following points. 1, moral certitude. 2, beyond a reasonable doubt. Now, members of the jury, the way I respond to this question is by, both parts of the question are answered by my rereading to you the instruction that I gave you, the definition I gave you on reasonable doubt. Now, I remind you, as I said to you earlier when I instructed you this morning, that even though I'm instructing you on a particular matter, you're to consider this instruction together with all of the other instructions I've given you during the course of this trial, specifically my instructions on the law just before you began your deliberations, but any other instructions I gave you earlier during the trial. To the extent that the definition I'm about to give you may differ even just slightly from the definition I gave you earlier, I do instruct you at this point to follow the instruction I'm going to give you right now. But with regard to, again, your questions are answered by my rereading to you the instruction on reasonable doubt. Now, what do we mean when we speak of proof beyond a reasonable doubt? The term is often used and probably fairly well understood, but it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, because everything in the lives of human beings is open to some possible or imaginary doubt. A criminal charge is proved beyond a reasonable doubt if, after you, the jurors, have compared and considered all the evidence, you have in your minds an abiding conviction, a near certitude that the criminal charge is true. As I've told you, every person accused of a crime is presumed to be innocent until proved guilty, and that the burden of proving guilt is on the prosecution. If, when you evaluate all of the evidence, you still have a reasonable doubt remaining about Cara Rintala's guilt, then Ms. Rintala is entitled to the benefit of that doubt and must be found not guilty. It's not enough if the prosecution has established a probability, even a strong probability, that Ms. Rintala is more likely to be guilty than not guilty. That is simply not enough. Instead, the evidence must convince you of Cara Rintala's guilt to a reasonable and moral certainty, a degree of certainty that satisfies your judgment and consciences as a jury of reasonable women and men, and leaves in your minds a clear, settled conviction of guilt. That is what we mean by proof beyond a reasonable doubt. Now, members of the jury, before I sent you out to resume your deliberations, I realized as I was reading this, I didn't have my tape player and recorder with me. So I will ask our court reporter to print up the instruction, and as soon as she has printed it and I make sure that it's accurate, that will be sent to you. But again, even though I've given you this instruction, again, even though you'll have it in printed form instead of in the form as earlier, with the recording device. It's just as important as all of the other instructions I've given you earlier, but to the extent that the instruction I've just given you may vary even slightly from the original instruction, please follow this instruction. Anything else, counsel? Rights being preserved?
No, Your Honor.
Okay, thank you. The jury is excused to resume its deliberation.
Jury, please rise. Call.
Counsel, if you just stand by until the court reporter prints that off so you can look at it, but I realize as I began reading that we probably should have, I think we all overlooked getting the recording device back in here. Anything else?
Yes, Your Honor. I just have to note, it was clearly audible to me just now, at least from one or more jurors as they were leaving, some statement of frustration regarding moral certitude, and that at least one of them is still left wondering what that means. Now, I understand that's not a formal communication from the jury, but again, I think this interjection of moral certitude, as they've misunderstood it, is fatally clouding their understanding of the standard here. And I would ask that somehow be rectified, because it's not a moral only certitude. It's moral, it's intellectual, it is rational.
Well, I didn't use the language moral certitude. I'm taking it from the instruction.
I know you didn't, Your Honor, but the jury clearly has some notion in their mind that that's the standard or that's part of it, and that's just not correct.
Do you have any other suggestions? But at this point, I'm not going to go beyond that. Thank you.
Court will stand in recess or rise. Yeah, that'd be fantastic.